I'll just introduce myself briefly. Again, I'm Emily. I'm a steering member of the U of T Law Union, which is co-hosting this event from the student end, along with the Palestine Forum out of the Monk School, which is of which Lena Lashin is president, and you'll meet Lena momentarily. So as students, we're so grateful you've joined us today for a critical conversation about Palestine and the law. Before we begin, I invite you to reflect on the fact that we at U of T and Osgood are all treaty people under the Dish with One Spoon Wampum Belt Covenant. So we are on the traditional territory of the Mississaugas of the Credit, Anishinaabeg, Seneca, Chippewa, Haudenosaunee, and the Wendat peoples, land which is of course home to many diverse First Nations, Inuit, and Métis peoples today. So we who are non-Indigenous continue to benefit from historical and contemporary forms of colonialism in Canada and globally. And so we gather here today in unequivocal solidarity with those seeking to dismantle and working to dismantle this colonial system. In addition, given the nature of our gathering, I also invite you to find a moment to learn about and honor the history of solidarity between Indigenous peoples in Turtle Island and Palestine. And so with that, I'll just give a quick word on where this event came from. So this event grew out of questions following the IHRP hiring scandal at our law school just last year. And the question was really, what do we know about the Israeli military courts used to impugn Dr. Valentina Azarova, her work, and the Palestinian human rights organizations she'd worked with? The irony is that in preparing for this event, we did some reading, and one of our firsthand observations was actually firsthand observations that we read of the military courts was itself written by then U of T law student Sophia Ijaz, who was then working as an IHRP intern at Adamir Prisoners' Rights NGO in the occupied Palestinian territories. Perhaps I should say, we're excited to be re-engaging in this conversation here at the law school. And if you'd like to continue the conversation beyond today, please stay in touch with Hearing Palestine, with TPF, with the Law Union, and we'll post these links in the chat. I'll now cede the floor to Professor Faisal Baba at Osgood for a few brief remarks. Yeah.
Thanks, Emily, and thanks to the organizers. I'm a full-time faculty member at Osgood. I have been since 2011. I'm also a member of the Nathanson Center. I'm one of the faculty members of the center, and the center is a co-sponsor of this event and of a series of events with Hearing Palestine. And I just like to say a brief word about the Jack and May Nathanson Center, which was established in 1997 thanks to a gift by Mark Nathanson of $3 million to create a permanent endowment for the center. Initially, it was focused on studying organized crime, money laundering, and police practices. A decade later, in the post 9/11 world, it was sort of rechartered, remandated to look more broadly at issues of state terrorism, state and corporate violations of human rights, and the activities of security intelligence agencies. And it is in this spirit that the Nathanson Center has hosted researchers, conferences, and supported Osgood students who do projects very much like the work of the IHRP at U of T. Our program is called the International Legal Partnerships, and we've built a network of partnerships with NGOs around the world. For me, this has been work that is very close to home because 20 plus years ago, I was a second-year law student who dropped out to go work for the Women's Center for Legal Aid and Counseling in Jerusalem, where my boss was the unit division of the Legal Research and Advocacy division, and that was Randa Siniora. And so it really is a delight to see Randa again after all these years. By some terrible travesty, we have not stayed in touch, and it's so wonderful to see her face on the screen and to welcome her to Osgood virtually, as it were. Randa, I pray that we're able to see each other in person one day again. Those years for the students here, that kind of experience, I can tell you, looking back 20 years, it was so formative. I learned more in the 2 years that I worked in Palestine with Randa and her amazing colleagues, a staff that was made up entirely, exclusively of Palestinian women. And I had the real joy and privilege of being immersed in that for 2 years and to learn from those women. And I learned more about the law and about the practical application of law to real world problems in those 2 years than I did in 3 years of law school. I can say that with certainty. So thank you, Randa, for that and for being here. Ardi is a cherished colleague on the faculty at Queen's, where I'm a graduate from. And Ardi and I also met 20 plus years ago when he too had gone to Palestine at around the same time that I did. And he ended up staying there much longer and having a much more distinguished career in Palestine than I ever could have aspired to. And we've found ourselves now as colleagues back here in Canada, a small handful of law professors who were excited to welcome Valentina Azarova and disappointed to find that we won't have her added to our ranks, but nonetheless, there is an understanding amongst a number of us in the law faculties that this work of increasing the profile for Hearing Palestine is really important. And I'm glad to be involved in this initiative. And so I think that's, I don't think I'm offering substantive introductions of our panelists. I'm offering more of a personal introduction. And so with that, I will turn it back over to the moderator.
Thank you so much.
Dina, we can't hear you. At least I can't. No, we hear scratchy. Am I the only one? Emily, can you hear Dina?
I can't hear her either.
Okay.
Okay.
Can't hear her, no.
Try again. Lena?
Okay, well, in that case, maybe we'll save. So Lena was going to introduce Hearing Palestine and the Institute of Islamic Studies. So maybe we'll come back to that at this point. And I can introduce our first speaker. So,
Sorry.
oh,
Hey.
You're back. Okay, go for it.
Is that okay? Okay, sorry guys, technology. So like Emily said, I'll just be introducing very quickly the Hearing Palestine initiative that Professor Baba just hinted at. And it is a new initiative at the University of Toronto that we are so happy and proud to be a part of and to make this event happen. It was established at the Islamic Studies Institute, but also in collaboration with various other departments, our history department, anthropology, NMC, religion, Center for US Studies. And so the Hearing Palestine initiative is primarily about providing an intellectual space for Palestinians, and of course, those interested in the history and the future of Palestine, to share their experience and their research and their ideas. And it's really designed to improve the university experience for students who are constantly and for far too long have been enduring and just generally concerned about the anti-Palestinian discrimination on campus. And essentially, it's a discrimination on our learning and on our capacity to learn. And so we encourage dialogue on cultural life, artistic creativity, social justice, current affairs in Canada, as Emily was saying, and the broader perspective of the Middle East in the Canadian context. And of course, this initiative is in solidarity with Indigenous struggles everywhere and encourage critical engagement with settler colonialism, sectarianism in the Middle East, Canada, and elsewhere. I will now introduce our first speaker for today, Professor Ardi Imseis, who is an assistant professor at the Faculty of Law at Queen's University. He is a member of the eminent international and regional experts, the UN Human Rights Council Commission of Inquiry into the Civil War in Yemen. Between 2002 and 2012, he served in a senior legal and policy capacities in occupied Palestine with UN Relief and Works Agency for Palestine Refugees in the Near East, and is also the former legal counsel to the Chief Justice of Alberta. He has provided expert testimony in his personal capacity before various high-level bodies at the UN Security Council and to members of the UK House of Lords and the French Senate. He is the author of The United Nations and the Question of Palestine, Rule by Law and the Structure of International Legal Subalternity. And that is a forthcoming publication, which we definitely look forward to. His scholarship has appeared, of course, in a wide array of international journals, and any law students here, I'm sure you don't need any remarks or introductions on his work, but some of them include the American Journal of International Law, European Journal of International Law, the Harvard International Law Journal, and the Oxford Journal of Legal Studies. So without any further ado, I will now hand the floor over to Professor Imseis.
Thank you so very much, Lena. I really am very grateful for the opportunity to address you all. And I should like as well to thank you for that very generous introduction. As well, most importantly, the folks at Hearing Palestine, the University of Toronto, which is an alma mater of mine, and Osgoode Hall Law. It's so nice to see many of you old friends who I've not been with for a very long time. It's widely accepted that the United Nations is the principal custodian of the rules-based international legal order. And so I am going to be focusing my comments today on this idea of the United Nations. It will be a critical set of comments on the UN, having spent many years working for it, including in occupied Palestine. But I give these comments in a sort of constructive vein in the hope that the UN can be better at what it does. And so it's widely accepted that the UN is the principal custodian of the rules-based international legal order. But what happens when the UN does not abide by or fully apply international law in its work? This talk is based on a recent article I published at the European Journal of International Law, in which I touch on these issues as they relate to the UN's management of the question of Palestine. The article specifically addresses the UN position on the legal status of Israel's prolonged military occupation of the state of Palestine, otherwise known as the occupied Palestinian territory, the West Bank, including East Jerusalem and the Gaza Strip. I claim that the UN's failure to consistently and clearly take a principled position on the legality of Israel's half-century occupation exposes a fundamental chasm in the organization's commitment to the international rule of law. Critical examination of the UN record itself reveals its position to be more demonstrative of what I have called an international rule by law, under which the promise of justice through international law and institutions is repeatedly proffered to a global subaltern class under a cloak of political legitimacy furnished by the international community, but its realization interminably withheld. Under international law, occupation of enemy territory is meant to be temporary, and occupying powers may not rightfully claim sovereignty over the territory they occupy. Despite this, since 1967, Israel has systematically altered the status of the OPT with the publicly declared aim of annexing it de jure or de facto. In the intervening 54-year period, the Palestinian people's right to self-determination in the OPT has been recognized by the UN, whose position has been held out as forming the only normative basis for its realization. Central to this, the UN has undertaken considerable documentation of individual violations of international humanitarian law and human rights law by the occupying power in furtherance of the UN's purported rule of law ordering framework, and yet it has paid scant attention to the legality of the occupation regime as a whole and the concomitant requirement, and this is the most important thing if you take anything away from the talk today, the requirement that it be brought to an end unconditionally in line with UN practice and the law governing state responsibility. Instead, the UN's emphasis has been placed on encouraging the parties to end the occupation through highly unbalanced and now completely defunct bilateral negotiations. One consequence of this has been for the UN to have provided a measure of legitimacy to Israel's occupation of the OPT at a time when the organization has been pivotal at the same time in developing a universally binding international legal proscription against all forms of alien domination, subjugation, and exploitation. I argue that through the UN's failure to consistently and clearly identify Israel's prolonged occupation of the OPT as illegal, the UN's position on the OPT runs counter to the conventional wisdom, which has presented the reemergence and relative gains made by the Palestinian people since the decolonization era as emblematic of the UN's commitment to uphold the international rule of law in their case. Simply put, the UN's recognition of Palestinian rights in the post-decolonization period has basically remained contingent and nominal in essence. In furtherance of these ideas, I wish to cover the following 3 points today. First, I will summarize the UN's position on the OPT since 1967 and why, counterintuitively, it is deficient from an international legal perspective. Second, I will explain why, on the basis of the UN record itself, Israel's occupation of the OPT is now illegal, and what the legal consequences of that determination require under international law. Third, I will discuss how urgent and creative recourse to the General Assembly and the International Court of Justice can help introduce a necessary corrective to this problem. So let's look at the UN's position on the OPT. A review of the UN record demonstrates 3 overarching and interrelated aspects of the UN's management of the question of Palestine in the post-67 era. First is the increased recognition of Palestinian legal subjectivity within the UN as a consequence of global decolonization, largely from the 1970s, 80s, and so on. Second is the proliferation of UN machinery focused on the humanitarian and managerial documentation of international humanitarian law and human rights law violations by the occupying power. And third is the UN's conditioning of the end of Israel's occupation of the OPT on negotiations. Each of these will be addressed in turn. First, in the decade following the emergence of the Palestine Liberation Organization in 1964, the UN General Assembly recognized the inalienable rights of the people of Palestine, including the right to self-determination, national independence and sovereignty, affirmed the denial of the Palestinian rights as the main impediment to peace, and granted the PLO observer status, including the right to participate in the deliberations of the Assembly on the question of Palestine in plenary meetings. The 1988 recognition of Israel by the PLO resulted in permission to use the designation Palestine in the organization, greater rights to participate in debate at the General Assembly, and following Palestine's failed 2011 application for UN membership, an upgraded status as a non-member observer state in 2012, thereby allowing it to accede to multilateral treaties, including the main IHL and human rights law instruments, as well as the Rome Statute of the International Criminal Court. This increased recognition of Palestinian legal subjectivity at the UN has grown, the pinnacle of which is the regular affirmation of the Palestinian right to self-determination in the OPT, a position reaffirmed expressly and impliedly by each of the General Assembly, the Security Council, the ICJ as the principal judicial organ of the UN, the Economic and Social Council, and the Secretariat through the Secretary General. Effectively, it's universally held at the UN. Second, since the decolonization era, there has emerged a proliferation of UN machinery devoted to the documentation of humanitarian law and human rights law violations by the occupying power in the OPT. Despite the broad scope of this machinery's cataloging of the occupying power's IHL and human rights law record in the OPT, it is notable for its conspicuous failure to definitively address the legality of Israel's very presence in the territory. Although occupation is meant to end under international law, nothing in the conventional humanitarian law and human rights law paradigm expressly compels this result. Rather, adherence to its norms merely operates to enhance the manner in which the occupation is administered, pending its eventual end. Thus, by focusing on the IHL and human rights framework, instead of failing to definitively identify Israel's occupation as illegal as such, the UN has privileged a humanitarian and managerial approach to the OPT over a remedial or emancipatory one. And this has ultimately lent Israel's presence in the OPT a legitimacy in which its legality has also been implied. Third, and most important, has been the UN's position that the end of Israel's prolonged occupation of the OPT must be contingent on the conclusion of negotiations between it and the PLO. This is a universally held position among each of the 5 relevant principal organs of the UN, most recently affirmed by the UN Secretary General, Antonio Guterres, who's gone so far as to assert that negotiations, bear with me, that negotiation is the only way to achieve the inalienable rights of the Palestinian people. While it is true that the UN's call for negotiation covers matters beyond the OPT as such, To the extent that this negotiations condition also qualifies the UN's position on ending the occupation itself, it is fraught with a telling paradox. Because the OPT has been determined by the UN to be the territorial unit within which the Palestinian people are entitled to exercise their right to self-determination under international law, the result has been for the UN to have frustrated, on its own terms, the very recognition it has bestowed upon the Palestinian people since decolonization. If realization of Palestinian self-determination in the OPT is a long-established right in the nature of what international lawyers call peremptory norm, derogation from which is not permitted, however can the realization of this right be left to negotiation between an infinitely more powerful occupier and a beleaguered and vastly weaker occupied people? This is particularly so if the occupation itself is or has become illegal through the acts of a bad faith occupant, which, as I will now demonstrate, is the case with Israel's occupation of the OPT. Understanding why Israel's prolonged occupation of the OPT is illegal requires consideration of at least three branches of international law. And forgive me, I realize this talk is rather technical, but I am a public international lawyer, so there you have it. These three branches are the law governing use of force, or the use ad bellum, the law governing how force is used in armed conflict, or the use in bello, otherwise known as humanitarian law, and international human rights law, including the law on self-determination. And because the OPT status is one of an occupied territory, the starting point necessarily under international law requires it to be the law of occupation. Two fundamental principles underpin the law of occupation. First, occupation is a temporary condition during which the occupying power may act only as a de facto administrator of the territory for the benefit of the protected population. Under no circumstances may an occupying power permanently alter the status of the territory, including through annexation, population transfer, or imposition of regimes inimical to humanity as a whole. Second, under no circumstances does the fact of being in occupation of territory entitle the occupant to sovereignty over it. Contemporary state practice, exemplified by the 2003 occupation of Iraq, affirms that the law of occupation defers to the principle of self-determination of peoples and its corollary, that sovereignty lies in the people and not in its ousted government. These fundamental principles are in turn rooted in the protection of at least three jus cogens norms of public international law. Again, norms derogation from which are not permitted. First, the prohibition of the acquisition of territory through the threat or use of force. Second, the obligation of states to respect the right of peoples to self-determination. And third, the obligation of states to refrain from imposing regimes of alien subjugation, domination, and exploitation inimical to humankind, including racial discrimination. Bear with me, friends, I'm getting some feedback, and I wonder whether or not we
Yeah,
can
I will.
Jens
I'll look into that.
There we are, thank you. In short, and bear with me, yeah. In short, and according to the UN record itself, Israel's 54-year occupation of the OPT has been maintained in violation of these three peremptory norms, upon which I shall offer a brief comment now. But as I do so, I should like to call your attention to the fact that at the heart of these three violations is Israel's policy of transferring its civilian population into the occupied Palestinian territory in violation of the Fourth Geneva Convention relative to the protection of civilian persons in time of war, the Rome Statute of the International Criminal Court, and customary international law. Since 1967, Israel has annexed, both de facto and de jure, a substantial portion of the OPT through a series of legislative, administrative, and other acts in contravention of the peremptory norm prohibiting the acquisition of territory through the threat or use of force. Thus, when Israel attempted to formally annex occupied East Jerusalem in 1980, both the UN General Assembly and the Security Council reaffirmed their own prior determinations, going back to 1967, that such a move was, quote, invalid, and decided that, quote, all member states are obliged not to recognize Israel's attempt to, quote, alter the character and status of Jerusalem. Beyond Jerusalem, Israeli actions elsewhere in the OPT have effectuated its annexation in all but name. This includes the expropriation of large segments of territory for Israeli settlements and related infrastructure. They include bypass roads, electrical sewage or sewage grids, tunnels, checkpoints, and other things. as well as the construction of the by now infamous wall and its associated regime declared illegal by the ICJ in 2004. As noted by a UN fact-finding mission, each Israeli government since 1967 has, quote, openly led and directly participated in the planning, construction, development, consolidation, and or encouragement of settlements, end quote, in the OPT through various political and military and or economic means. Today, according to the Secretary General of the UN, between 19 and 23% of the population of the West Bank, including East Jerusalem, are Israeli settlers, and their numbers continue to grow. Israel's violation of the Palestinian right to self-determination in the OPT has equally been driven by its settlement policy. According to the ICRC's commentary on the Geneva Conventions of 1949, done up by Jean Pictet in the 1950s, the prohibition codified in Article 49 of the Fourth Geneva Convention on civilian settlement by an occupying power was intended to prevent demographic changes in occupied territory, quote, for political and racial reasons, end quote, and to frustrate attempts, quote, to colonize, end quote, such territory. Yet according to the UN record, that is precisely what has happened in the OPT since 1967. Thus, in 2012, the Secretary General reported that the current configuration and attribution of Israeli control over the land in the OPT, quote, severely impedes the possibility of the Palestinian people expressing their right to self-determination. He noted that, again, quote, because the settlements are scattered across the West Bank, including East Jerusalem, the territory of the Palestinian people is divided into enclaves with little or no territorial contiguity, with a resulting fragmentation that undermines the possibility of the Palestinian people realizing their right to self-determination. Finally, Israel's settlement policy has introduced a system of government in the OPT that, according to the UN record, is systematically engaged in racial discrimination as proscribed in the International Convention on the Elimination of All Forms of Racial Discrimination, what we call CERD, to which Israel, of course, is signatory without reservation. Israel's view that the international human rights law in general, including CERD, does not apply to the OPT has been rejected by the UN, including the ICJ. The racial discrimination underpinning the regime Israel has erected through the imposition of exclusively Jewish settlements in the OPT is systematic and widespread. As such, in its concluding observations on Israel's 2012 periodic review under CERD, the UN Committee on the Elimination of Racial Discrimination observed that Israeli settlements in the OPT, quote, are an obstacle to the enjoyment of human rights by the whole population without distinction as to national or ethnic origin, end quote. It declared, quote unquote, extreme concern with Israel's policy of de facto segregation, their words, not mine, between settlers and Palestinians in the OPT, bolstered by, quote, two entirely separate legal systems, and the hermetic character of the separation of the two groups, concretized by a complex combination of movement restrictions that only impacts the Palestinian population, end quote. These findings were subsequently echoed by a UN fact-finding mission, which decried the, quote, legal regime of segregation, end quote, in the OPT, enabling the creation of a privileged legal space for settlements and settlers, while violating the Palestinian rights to non-discrimination, equality before the law, and equal protection of the law. The racial discrimination inherent in Israel's settlement regime in the OPT has given rise to concern that it is also engaged in the crime of apartheid, a view now publicly shared by Human Rights Watch and Israel's own leading human rights organizations, B'Tselem and Yesh Din. As none of these apartheid studies represent the view of the UN, however, the organization has yet to make a definitive pronouncement on that matter, the matter of apartheid, despite the urging of the President of the UN General Assembly in 2008, forgive me. I'd like to shift the chat a little bit. You might ask, why does legality of the occupation even matter? I mean, this is a situation of hyper legality, that is, Palestine has overly been prodded and poked with international law and by lawyers arguing from all sides. So why does legality of the occupation itself even matter? At the heart of the issue is the tension between the UN's position on the OPT with the relevant international law governing state responsibility. On the one hand, is the political consensus that the emergence of an independent Palestinian state in the OPT can only arise through a negotiated withdrawal of the occupying power. On the other hand, is the relevant international law concerning the responsibility of states for internationally wrongful conduct, an elemental foundation of which is the proposition that states may not negotiate the consequences of their illegal actions. Under the law of state responsibility, the legal consequences of Israel's illegal occupation of the OPT are simple, and they're threefold. First, it must end, that is, Israel must end the occupation forthwith and unconditionally. Second, it must offer appropriate guarantees of non-repetition. And third, it must make full reparation for injury caused, including any material and moral damage. Given the occupation involves gross and systematic breaches of Jus Cogens norms, additional consequences for third states, and this includes Canada, require them to cooperate to bring the occupation to an end through lawful means and to refrain from rendering aid or assistance in maintaining it. Because states may not do collectively that which they are prohibited from doing individually, these third state obligations necessarily set the parameters of what the UN is obligated to do as an international organization. All this to say that the UN's conventional approach of conditioning the end of Israel's illegal occupation of the OPT on negotiation is problematic for at least three reasons. First, it runs counter to prevailing international law on state responsibility, which does not contemplate states negotiating the terms of whether and how their internationally wrongful conduct is brought to an end. Second, it runs contrary to its own practice, that is the UN's own practice on foreign military occupations in other contexts. Where an occupation has been determined by the UN to be illegal, as is the case, for instance, with Namibia or Iraq's occupation of Kuwait, the obligation to bring it to a speedy end has never been conditioned on negotiation, but rather has been unconditional in line with the law of state responsibility. And third, it renders conflict resolution more difficult by providing a measure of legitimacy to Israeli claims on the OPT without full regard for its track record of bad faith, again, as established ironically so by the UN itself. In the over quarter century since negotiations began at Oslo, Israel has consolidated its hold over the OPT under a public claim that it will never relinquish it, in complete contravention of the norms underpinning the law of occupation and the UN Charter. How calling for continued negotiations in such a context can be regarded as an effective form of dispute resolution instead of an effective endorsement of the internationally wrongful acts of a hegemonic party beggars belief. So the question arises whether it is possible for the UN to correct its position, and if so, whether this would vitiate Palestine's contingent status in the organization. To this end, it is submitted that both the General Assembly and the International Court of Justice should be looked to as potential sites where the illegality of the occupation of the OPT can be definitively established. The operative word here is definitively. This is because for a short period of time between 1977 and 1981, the General Assembly already characterized the occupation as quote unquote illegal, while it called for Israel's quote immediate, unconditional, and total withdrawal, end quote, from the OPT up to at least 1991. The UN record indicates that these principled positions of the GA simply stopped in 1992, perhaps in deference to the Middle East peace process then in its early years. Following almost 27 years of process, however, there's been little peace to show for it. On the contrary, the UN record demonstrates that Israel has used this time to consolidate its hold over the OPT through pursuance of its illegal settlement program. In view of this, I believe that the Assembly should be re-engaged in order to revive its position on the illegality of the occupation. This would furnish it with greater leverage to call for the unconditional and immediate end of the occupation in line with the law of state responsibility. Another possibility would be to seek a second advisory opinion of the International Court of Justice, the principal judicial organ of the UN. The proposed question could ask for guidance on the legal consequences for all states and the United Nations arising from Israel's continued settlement and prolonged occupation of the state of Palestine, in particular, whether the occupation is illegal and when and how it must come to an end in accordance with international law. There are other iterations of similar questions, but that's the nub of it all. Such a question would allow arguments to be advanced that go to the illegality of Israel's occupation based on the Jus Cogens norms I've set out above. A second advisory opinion would possibly enable the ICJ to determine that Israel's very presence in occupied Palestine has become in and of itself illegal, and that its end cannot reasonably be pinned to continued negotiations between a bad faith occupant and a besieged and captive people, but can only be fulfilled through immediate, unconditional, and full withdrawal in line with the law on state responsibility. In conclusion, at a time when the credibility of the UN is arguably at an all-time low, it behooves those of us who care about the post-World War II multilateral international order to identify how the organization can do its work better. To my mind, one of those low-hanging fruits in this regard is to ensure that UN action remains consistent with its principal purpose as affirmed in its charter, namely, quote, to maintain international peace and security, including the suppression of acts of aggression or other breaches of the peace in conformity with the principles of justice and international law, end quote. One way it can do this is to be more consistent and fulsome in its application of relevant international law in its positioning on the OPT. Based on a review of its own record, there's no principled reason why the UN should not be able to definitively determine Israel's over half-century-old occupation of the state of Palestine as illegal in and of itself. Doing so will not only bring the parties closer to ending the tyranny of foreign military occupation that has blighted the lives of generations of Palestinians and, it must be said, Israelis, but it will go some way in helping the UN mitigate the effects of its selective international rule by law through the application of a truly universal international rule of law. And with that, I should like to thank you. That is the end of my remarks, and hand it over back to you.
Thank you so much. So I'll now introduce our second speaker, Randa Siniora. So Randa Siniora is the General Director of the Women's Center for Legal Aid and Counseling. She is a human rights and women's rights activist with professional experience in the field of international human rights and humanitarian law for over 35 years. Earlier, she was the Senior Executive Director of the Palestinian Independent Commission for Human Rights from 2007 to 2015, and the General Director of Al-Haq, Law in the Service of Man from 2001 to 2005. She also headed the networking and advocacy at the WCLAC, the Women's Center for Legal Aid and Counseling, and worked as a legal researcher and coordinator of the Women's Rights Program at Al-Haq. Randa Siniora was the first Palestinian woman ever to brief the UN Security Council on women, peace, and security in 2018. In 2019, she was selected among the 100 most influential people in gender policy around the world, one of the largest, most prominent global lists that was drawn from over 9,000 nominations to recognize and celebrate the hard work being done on gender policy by many around the world. Randa has an LLM in International Human Rights Law from the University of Essex and an MA degree in Sociology Anthropology from the American University in Cairo. Welcome, Randa.
Thank you very much, Emily, for this extensive introduction. I really appreciate it. And I'm so glad to be with you today at the University of Toronto and Osgood Law School. And I'm so happy to see some of my old friends here joining today with the nice memories of working with Faisal. I was at WCLAC then, and we worked very closely together. And Ardi, we met a lot and worked together, and all of you who have been working and organizing for this important event. I'm really modest, and I don't know how could I start after this very extensive legal introduction with all this critical analysis that Ardi has given. And perhaps I thought that I will start by saying that in 2018, when I was speaking at the open day at the Security Council on the Women, Peace and Security agenda, I was really speaking to the states, permanent members of the Security Council and other members, all states at the Security Council. And I said one thing which I would like to link with Ardi's presentation, that the United Nations has been established under the Charter to maintain peace and security. What we see in the Israeli-Palestinian conflict is that the Security Council is managing conflict rather than resolving that conflict, and that they have no intention to really, based on their numerous resolutions in support of the Palestinian question and the Palestinian right to self-determination, to end a prolonged belligerent occupation and to allow the Palestinians to practice their right to self-determination. What we see is completely the opposite. What we need is not additional UN resolutions, by the Security Council or the General Assembly or other UN bodies. We do not want another advisory opinion, Ardi, because the advisory opinion of the International Court of Justice in 2004 regarding the wall has really re-established and reconstructed the very fact that this is an illegal occupation that should come to an end. It was really extensive on explaining that both human rights and international humanitarian law apply to the occupied Palestinian territory occupied by Israel in 1967. It had established that the illegal annexation of Jerusalem and the imposition of Israeli law over occupied East Jerusalem is also illegal. So we have all the illegalities. We also hear the Human Rights Commission every day coming in with new decisions and resolutions and taking decisions for a commission of inquiries and missions to Palestine, and the latest one, which was in the May after the Israeli military aggression on the Gaza Strip, which is really a precedent with an ongoing commission of inquiry to investigate the Israeli violations and military incursions on Gaza every few years. And it is really the first time that it is a mandate that is open until, without a closed mandate, including Palestinians, wherever they are in Palestine, in the occupied territory, and inside Israel, which really starts to establish for a different. Now we started to use more the word of this apartheid regime that we see. That is really discriminating against the Palestinians, even inside Israel and in the occupied Palestinian territory and in East Jerusalem, with different legal statuses that apply in the occupied Palestinian territory. If I want to speak today about the Israeli military court system, which is really part and parcel of this whole apartheid structured regime, I would say that this system is overloaded with structured deficiencies, as it is designated since the beginning of the Israeli military occupation to an instrument of sustaining occupation rather than achieving justice. While you say, when you speak about a military justice system, that you expect that to have real due process, have guarantees for achieving justice. I will quote here that the military courts system is in no way a military court system that is not impartial or neutral or arbitrary, nor can they be. They are firmly entrenched on one side of this unequal balance between the occupied and the occupier, and serve as one of the central system maintaining Israel's control over the occupied Palestinian territories. This system is really trying to control the Palestinian people, control their lives, and bring them to custody under very harsh conditions. It is in no way a legal system that maybe gives the impression that it is legalizing issues, but it is really based on illegal occupation and illegal practices to control the Palestinian people. As with the advent of the Israeli occupation, or with the control over the occupied Palestinian territory in 1967, Israel has maintained that it will respect international law and that they will not impose their own laws and legislation on the occupied Palestinian territory. But what we have seen that numerous military orders have been established that have amended or changed laws that have been enforced prior to the Israeli occupation that had really controlled the whole lives and every aspect of the Palestinian life. Within that system, of course, the Israeli military courts are really coming in with military orders that have established how the structure and the functioning of the court system will continue. And initially, it was supposed that the Israeli military court system will be relevant to all Palestinians and Israelis, as well as settlers, Jewish settlers in the occupied territory. It ended up with being only a control mechanism over the Palestinian people, a suppressive mechanism against us, while a decision was taken at a later stage that Israelis inside the occupied territory and illegal settlements and settlers will be brought before civilian courts inside Israel. So we're seeing here also again a discriminatory apartheid regime, which is only focused on controlling us as Palestinians while allowing Israel to go ahead with and Israeli settlers to control the lives of the Palestinian people and play a role in this complicity with the Israeli military regime to control the lives of the Palestinian people and their property and their land. Israel justifies the presence of Palestinians in Israeli prison and detention centers by labeling them as security prisoners, and they are brought before these military courts rather than political or freedom fighters. We are not seen as freedom fighters fighting for our right to self-determination, our right for our homeland. We are seen all the time as being a threat to the Israeli security, and the Israeli target us and target the political leaders, elected representatives, academics, journalists, human rights defenders. It consistently resorts to the incarceration as a tactic of political control, correspondent to its intent to instate a colonial domination, preventing the possibility of putting an end to occupation. There is no intention at all, and the international community, including the United Nations, I have no intention to end this military occupation. And I think if there was this political will and the interest of the states, it should not necessarily go through only the channel of negotiations. But I believe that this is not the intention at all. It is politically motivated and a direct result of the persistence of a colonial prolonged military occupation and an apartheid regime that controls the lives of the Palestinian people and their natural resources and their own lives. The main function of the Israeli military court system is to prosecute Palestinians who are arrested by the Israeli military and charge them with security violations, quote unquote, and other crimes as defined by Israeli laws and Israeli military orders that have been initiated. However, these orders enforced through the military courts also criminalize a wide array of other types of activities, including certain forms of political and cultural expression, association, movement, nonviolent protest, and all these, and also even traffic offenses. After the Oslo Accords, nothing has changed with the separation of division of with the giving some control to the Palestinian Authority over Area A and partial control over Area B, keeping the control over Area C for security considerations. The Israeli military system and the whole legal system continue to function as before, and Palestinians continue to be brought before these Israeli military courts. Remand in custody is the rule. It's not, trying to find other means of control before arresting people and keeping them under custody. The military judges are supposed to rely on 3 conditions stipulated in the Israeli law for approving remand in custody. The first one is the prima facie evidence to prove guilt. The second one is the grounds for arrest and lack of a relevant alternative for the detention. But what we see in reality is that the Israelis always arrest, and most of the people that are being arrested are brought before military courts. 99% of those who are brought before these military courts end up by being convicted. In most of the cases, the plea bargains are the rule for most of the cases, because the people who are being arrested, Palestinians, over 800,000 Palestinians have been arrested since the Israeli military occupation in 1967. These are being brought regularly before the courts. We see the military raids regularly taking place every day, every night, and we see the result of the arrest that takes place, and they're bringing in minors, they're bringing in women, and they're bringing in also male, mostly male. We can say around 40% of the male population have been at one point arrested and detained by the Israelis. After the end of the interrogation period, the proceedings in the court system start. Now, what happens is that the Israelis have the ability. The first 8 days, nobody could meet during the interrogations, and nobody is allowed to see these arrested. It could go on for 90 days and renewed after bringing the detainee or the defendant before the military court for another 90 days before the court proceeding starts. The court proceedings themselves are very long. They take such a very long period of time to proceed. It could be up to 2 years. So most of the people prefer to plead guilty in order to be convicted quickly and get their arrest for small acts, like, for example, throwing stones on military vehicles or small convictions, and therefore better than being arrested for sometimes periods that are longer than the time they would be arrested if sentenced. This also happens with the minors, and in most of the cases, families prefer and the lawyers prefer to make this plea bargains with the Israeli military courts in order to reduce the period and release the minors from prisons. Now, what happens after being released, especially in East Jerusalem, is that these are being detained at home after being released on bails, and the women become the prison guards of their own children. Many of the women are becoming the prison guards and are really controlling the lives of their own children at home, because they will have to pay very high fees if they are, or bails if they are violating the right. They have to stay away from confrontational areas. And we see the double burden or the brunt on women who have to control their own children, and sometimes they have to abandon their jobs, and all of that because of this military court system, which really brings in the minors. Although there has been changes and amendments in the law that allows considers that all children under 18 are minors, and like the Israeli law, in practice this is not the case, and Palestinian children are treated as the elderly, and are if they are above 16 years of old, they are detained with the ordinary detainees, and therefore the whole system is really functioning and machinated, if you will, which in order to convict the Palestinians, control the lives of the Palestinian people, and not really allow them to function. In 2010, the UN Special Rapporteur on the independence of judges and lawyers found that the legal foundations and practices of the military justice system do not comply with international standards, and that the exercise of jurisdiction by the military court over civilians not performing military tasks is normally inconsistent with a fair, impartial, and independent administration of justice. Such court system is discriminatory in its nature. Palestinians in the occupied territory endure a discriminatory application of the military court system that does not comply with international standards of fair trial and administration of justice. These discriminatory measures include larger interrogation periods of Palestinians, lengthier trials, discriminatory sentences. If we come to the administrative detention, which is also very common in the Israeli military courts, persons are being arrested without charges or trials, administratively for 6 months, renewable another 6 months, and indefinitely. With what they call it, the secret evidence. They claim that there is secret evidence, and that these persons will be arrested indefinitely without charges and trials. I really very much got impressed by Damir's testimonies of those interns who have been, and students who have been interning with them and have monitored the court system. What they said on this court system is that one thing about it, like what Abbas Khan has said in the document that has been distributed among the students, I think, it says that he was struck, he was mostly struck that how these military courts look as being temporary. The waiting area wasn't so much a room as an outdoor pen surrounding by a fence topped by a barbed wire. The courtrooms did not look like any courtrooms he had ever seen in the United States. From the outside, they reminded him of the trailer park, small, seemingly temporary counterparts laid out side by side. He also goes in his testimony from his own observations to say it was surprisingly to see how such disorder, that there is disorder in the military order. Although it's run by the military, the judges are military, the prosecutor is from the military, the translator is from the military, and the other people he did not know what they're doing in the room are the military. He also noticed that the courtroom looked like very chaotic and really very much not disciplined as expected by a military court. In another way, in another testimony, which I also liked by Peter Hannan, he also stresses the fact that the courts looked very unlike the courts he ever known. They are not really well equipped. They are made, they are courtrooms. They go from cage to cage, and once you're there, you're in a room, in rooms that are not really very, very equipped. He says, I also while I cannot understand the language, he says, I understood quickly that there were no arguments being submitted, no testimony collected, nor any form of regular procedure I would associate with criminal proceedings. This was very much political. The judge was in charge. Mainly the judge being in charge, no doubting this. He issued commands above the statements of others and appeared not to hear that which he did not want to. We always at WCLAC used to accompany our delegations to the military courts in Ofer. We have two major military courts functioning in the occupied Palestinian territory. One in Ofer near Ramallah, another one in Salem in the northern part of the occupied West Bank. And there are other 4 courts that are in conjunction closer to interrogation sectors inside Israel that conduct these military courts. What was very impressive is that we also used to take observers, especially to see the mothers of the minors who are being brought before the courts at Ofer. And it was it's very touching to hear the controversy between the fairness and the chaotic work of the military at one point, and by the role that the mothers in encouraging their children, the minors in conducting the court, in the courage they have to support their children who are being arrested, and how they have been able to impress them. This is really coinciding with what also Peter Ham has said in his testimony, that you see the antithesis of beauty when you see the families with pride touching their children, joking with them, and being proud with smiles that show their pride of being freedom fighters, not being security threats to the Israeli Authority. All of that really reflects this thesis and antithesis, the thing and the contradictory, where we look at ourselves as freedom fighters. Many of us as Palestinians who are being brought before the military courts are always coming with courage, because we know that we have the right to our own homeland, to our country. And we know that we have, unlike maybe Ardi speaking very legally, I speak as a person who lived most of my life under Israeli military occupation. I was hoping that my son and my children will have a better future, but it seems that even our own children are going to see their own children facing this occupation. I do recall my parents hoping that I'll have a better future. But I was 6 when the occupation was there. And I'm speaking from a practical experience, not only as a human rights defender, but as a person who lived most of her life. I'm 61 years old. I lived most of my life under the Israeli military occupation. I've seen that at checkpoints, in military corps, in practicing my own profession as a human rights defender. We are always being attacked because we are human rights defenders. We are being also, our spaces are being shrinked. Our attempts to fight against the occupation are being obstructed. We now see one of the human rights defenders, the director of the women's health committees, who was also a colleague of mine at WCLAC, who has done marvelous work, being attacked and being under arrest. She's 61 years old. She's also under detention. She is being brought before the military courts, and they are proceeding with that for the past 3 months. They do not take into consideration the specificity of the situation for the women political prisoners who have families, who have children, and are being separated from their own children. The mothers of the detainees are suffering because they are themselves arrested, but also their children are being arrested. They have to protect them from military raids and to protect them from the experience of being brought before Israeli military courts. This is a situation that we want to end immediately. We cannot wait to see Palestine being liberated, because we believe that we are Palestinians that have the right to our own homeland. And we see the Israeli settlers expanding over our lands, our resources, with the support and protection of the Israeli military and police. And this is, I think, only to end my talk, I think this is our right as Palestinians and Palestinian women to see an end to this prolonged military occupation. Thank you for giving me the chance to speak. I'm sorry if I took more time than...
No, this was wonderful. Thank you so much, Randa and Ardi, for these really stimulating and powerful, really powerful talks. My name is Alejandro Paz. I didn't get a chance to introduce myself to the audience prior. I'm Associate Professor of Anthropology here at the University of Toronto. Besides thanking you both for those powerful talks, I wanted to express how timely they are for events that are happening here, because in a sense, the Israeli state regime over the Palestinians has direct impacts on the Palestinians living or subject to it, in especially the occupied territories, but also on our discourse, even in Toronto, what can be said and what cannot be said. And I'm sure both of you have experienced this yourselves in different ways. And it happened recently that a prominent journalist and anti-racism activist, Desmond Cole, who I believe is in the audience today, thank you for joining us, Desmond, was giving a seminar to the Toronto District School Board, and happened to say Free Palestine, and also said that the occupation is illegal, and he's facing enormous backlash from having made these comments, and very clear-eyed comments that are not in any way, I think, controversial with a more scholarly eye. But the way that this regime functions to try to limit discourse about it is making an appearance here. And so your talks today are particularly timely for that reason. And we've posted an article by Desmond about the limits of speaking about Palestine and anti-Palestinian racism in the TDSB, as well as another one by Mark Ayash, a colleague, a sociologist colleague at Mount Royal, from The Breach. We encourage you all to have a look, because this is very important a time in public discourse in Canada as in many other parts of the North Atlantic. And I'm now going to turn it over, I believe, first to Emily, who will convey some of the questions that we came up with as a group when we did our reading group. And my apologies for the noise in the background.
Sure. Yeah, so just quickly, I put in the chat some resources, including the articles Alejandro mentioned, and the articles that we read as students in preparation for this event, which both of our speakers referenced. And then also for those of you who may have to leave early, I know law school classes start again at 2:10. We put how to keep in touch with us as well. So in terms of questions, I think what you just raised, Alejandro, is really a perfect lead in. So one big question we kind of had together as a group is reading the reports from Ademir and B'Tselem and listening to both of you, it's very clear that the military courts do not constitute a functioning legal system for Palestinians. So the question is, why does the Israeli state go to the trouble to create the appearance of law when judging Palestinians and even make case law? And, you know, what prevents more people from condemning the military court as illegitimate, especially given the use of those convictions against Palestinians abroad, or their advocates, I should say. So I'll open the floor for either of you to jump in and respond to that.
I'm happy to.
Go for it.
Now, although my talk didn't address the military court system in any detail at all or by name, only because the military court system is part of a larger structure of a whole host, a multiplicity of discrete illegal actions by the occupying power that run the gamut of all aspects of life. It could be, for instance, deportation of individuals, settlements, usurpation of natural resources. It could be any number of actions. The military court system are part of that. The violations, the discrete violations of international law that take place through the military court system are extremely disconcerting, and Randa did a wonderful job of discussing them. The question that you ask is, why does Israel go through the trouble, if you like, of even having a military court system? I need now to take your viewers and to take you back a step. This has nothing to do with Israel. In a sense, occupation under international law is a regime. It exists, and it's governed by treaty and customary international law that allows occupying powers, indeed requires them to, administer public order in an occupied territory. Now, part of the administration of public order in an occupied territory requires that the occupying power respect the laws in force at the time of that they take over the territory in question, which include criminal law. But at the same time, the law of belligerent occupation allows an occupying power, indeed requires an occupying power, to adjudicate breaches of the peace and so on, very broadly understood. Now, this is, if you like, the site in law where there's a clash between the interest of an indigenous people who are struggling for their right to self-determination under what is meant to be a temporary situation that has now lasted 54 years, and an occupying power that has very clearly used and abused its authority under the law of occupation to further a patently illegal objective, that is to colonize the territory of the occupied Palestinians and to acquire it illegally through force of arms. You say, why does Israel use the law? Well, the question is just as easily put. Why do states, including those states that violate law, because states do, why do they even have recourse to law? And that's not only a philosophical question, but it's a practical one too. Because law provides, for instance, a legitimacy to it. And so this is not unique to Israel. If there is an administration of law that can be pointed to by the occupying power, then therefore that colors what is legitimate and not in the circumstances. And that is why it is so eminently important to delve deep on what the facts are at issue whenever somebody raises the validity or not of an Israeli military conviction. Randa had set it out quite well, and I would refer your readers on this particular point to the work of Yesh Deen. There's a wonderful book they did some years ago called Backyard Proceedings, which assess and examine. This is all available online. Yesh Din is one of Israel's most prominent human rights organizations, which, to my recollection, and I'm sort of paraphrasing them, they look at the military court structure as administered by Israel in the occupied Palestinian territory and identify the process that Randa had set out. Some 98% of all cases go by way of plea bargain. And that plea bargain is usually the product of information culled from, that is collected from the detainee in the first week of their incarceration or in the early period of their incarceration, during which time, as was pointed out by Randa, they don't have access. In fact, they're forbidden from access to counsel. And sometimes they're taken outside of the occupied territory and put in incarceration
illegally
in Israel, illegally, in violation of the 4th Geneva Convention. It's a war crime to do that, right? And so when you're in incommunicado circumstances and quite possibly being tortured, right? And there's a history of Israeli use of torture, notwithstanding the rulings of the High Court of Justice in Israel that torture, or at least the methods used by them, are not to be used. Torture continues. See myriad reports of B'Tselem and Yesh Din on this. In those circumstances, and the use of secret evidence, right? You have a multiplicity of violations of due process rights of individuals that are part and parcel of the system in question that give rise to confessions, because the alternative is much worse in real terms. People are held in incommunicado detention without charge or trial indefinitely until such time as they cop a plea. And so a plea is going to start looking good if you're staring down, 2 or 3 years behind closed doors in a jail cell without access to a lawyer or your family, et cetera, et cetera. So all this to say, law matters. It matters both to states who use it. It matters to those who are subject to it, you and I, individuals, and at the international level, non-self-governing peoples, including people of Palestine in an occupied territory. It matters because it provides legitimacy. It also provides order and predictability. It can be abused, but it can also be used creatively. I'll stop there.
Thanks. And Randa, I saw you nodding your head. Yeah.
Can I say something? I fully agree with Ardi, of course, and just going back to 1967 Israeli military occupation. At the beginning, they accepted the applicability of the 4th Geneva Convention on the occupied Palestinian territory. And then they, after a few months, 3-4 months, they decided that they wouldn't, although they have signed and ratified the 4 Geneva Conventions, including the 4th, relevant to the protection of civilians at times of war or under occupation, they backed up and said, no, we will only take the humanitarian, quote unquote, provisions of the convention, which is really very, not logical, because if you look at the 4th Geneva Convention, it's all about humanitarian aspects and how you treat civilians and protected civilians at times of war or during conflict or under occupation. I think the reason is that Israel insists that they are not occupying the West Bank, they are administering it, and that they're respecting international law. But what they do, in fact, is that they create facts on the ground every day to maintain their control. It's a creeping annexation, a colonial occupation regime, apartheid regime that is trying to control through the slogan that they always raise, that Israel is the only democracy in the Middle East. You hear it times and again. This system is a democratic regime, and that's the only democracy in the Middle East. And therefore, they want to establish that what they do is really giving us the chance to be for a fair and just trial, while what is happening is actually what was presented in the different observations of the interns of Adamir. It's chaos, and it's a control by the military without any kind of prima facie evidence. They say, we need evidence. It's enough for somebody who's under torture and interrogation, deprived of being sleeping in complete isolation for a long period of time to confess over any act that he or she has done. And then, or it's enough that somebody would say that this person or two persons say that this person is a member of one of the political parties which are considered as terrorist Palestinian political parties, which really makes enough for them to bring convictions against those people. So they want to be on the surface, superficially perceived as a democracy, that they're only administering the territories, not occupying the territories, but at the same time, establishing facts on the ground, allowing for further annexation and control over the land, disrespecting international law, but getting the legalization that what all they do is legitimate. It's controlled by law, and it's not really without the rule of law. So it's an illegal occupation that trying to establish itself and brings legitimacy to its occupation through using the law as a tool in their own benefit. They never refer to international law. They sometimes use Israeli law, but not in our benefit. And also, again, it's only superficial. Even the Palestinians were often very hesitant, and some of the Palestinian lawyers have boycotted Israeli military courts and have decided that they would not use it. But the practical experience, and because there are thousands of Palestinians, as I mentioned, who are being annually or daily arrested by the Israelis and brought before the military courts, there has been a need for the Palestinian lawyers to work. Sometimes the people also question the Israeli High Court of Justice. And when the cases are, lawsuits are brought before, or cases are brought before the court, the Supreme Court, some people are suspicious about it because it's always ruling according to the Israeli law in favor of the colonial occupation and not in favor of the Palestinian people. But despite that, there's sometimes a small leverage. Sometimes, for example, in building the wall, you find that there's a little bit of leverage that they would deviate the channel of the wall in a way that saves some of the Palestinian land. And so the people would really look for the practical part of it, although knowingly we are very sure that this is a colonial occupation that is expanding on the expense of the Palestinian people's property and land, and they're doing it in a way in the military courts and everywhere else within a whole comprehensive regime to control us as Palestinians and to control our resources and deprive us of our right to self-determination as Palestinians who have the right to this as stipulated in numerous international UN resolutions.
Thank you so much, Professor Imseis and Ms. Siniora. This was a very enlightening and insightful answer to that question. I think just intuitively, the next question should be kind of about alternatives. So we did mention the failures and the shortcomings of the legal systems that govern Palestinians. I know, Randa, you've made mention that there's really little merit in asking or creating any more resolutions. We're done. Ardi made note of the paradox in even asking an occupying power, or expecting an occupying power to administer the justice themselves. And I know that Adamir's report mentioned the Israeli and human rights activists that were attending the court sessions and put out the testimonies, kind of invoked a lot of European diplomats to kind of monitor and implement monitoring systems in the courts. So it seems that they were hinting that, definitely the presence and vocality of it is creating a little bit of pressure on the judges. But I think I ultimately just want to ask, how can we circumvent the tension between how often Palestinians are constantly appealing to international law and they're saying this resolution was not upheld and this resolution was not respected and these laws were violated, but the response from international human rights, or sorry, international law community has been inadequate, to say the least, when it comes to this justice that we need. And I think I also hope that maybe even Professor Imseis can speak to law students and international law students and maybe global affairs students who perhaps want to kind of make a career of international law. Where is the legal principle and legal element that's worth looking into, worth advocating for? Is it a convention? Do we need regional conventions, a special tribunal? Like, you know, what elements, if any, are there?
A good set of questions, Lena. I suppose I'll propose to begin in trying to answer them. This is not unlike any question that I would have asked of me, my own students at Queen's, where I teach public international law. You say, how do you resolve the tension, if you like, between a principle, law, and power? I'm now paraphrasing you. Power that refuses to, if you like, show enough fidelity to a law. Power that abuses law. And I'll make it quick. You cannot resolve that tension. It is a tension that is a marked feature of the international legal and relations order. And if you try and resolve that tension, you'll be banging your head against a brick wall. What you must do, this is my respectful view based on years of experience, is accept that that tension is part of how the international legal order works. And once you do that, then you can find relevant entry points where law can be creatively used toward the proper end of its object and purpose, right? So there's a lot of international law that is valuable. All of the international law that Randa and I have cited is well-intentioned and rooted in normative values, universal values, or at least values that should be universally applied. So law isn't the problem as such. It's lack of respect for it. And so it's trying to find those entry points politically, economically, socially, culturally, those entry points where law can be put to use for what it was meant to do. And in this case, in the case of the Palestinians, but again, the Palestinians are not unique by any means. There are many aspects of their situation that is unique. But I mean, in this context, in the context of which I discuss now, this tension that you've raised, they're not unique by any means. So for instance, Randa, this is a great opportunity for me to reply to my colleague Randa on her point that we don't need another advisory opinion of the International Court of Justice. I am of the view that we do. Now, the reason why I take that view is that despite the problems that exist in the UN's position on the question of Palestine, which I've tried to set out and which I will set out in my book and so on, law can still be, there's enough law that can still be used and a number of institutions that can still be utilized toward the just end that the Palestinian people seek and to which they're entitled. The 2004 advisory opinion on the wall, for instance, was limited. With respect, Randa, at no point in that advisory opinion, save and except mistakenly, I should add, in the separate opinion given by Judge Ardi, not the majority opinion, is there any reference to the illegality of the occupation? And Ardi was mistaken when he mentioned it. Occupation is not, as a matter of international law, ipso facto illegal. It can be, but not in general terms. And the court did not say at all that Israel's occupation of the OPT was illegal. The court focused on the legality of the wall, declared it to be illegal. It declared many of the discrete acts of the occupying power, settlements, annexation, to be illegal, annexation of East Jerusalem and so forth, to be illegal. But it never did say that the whole of the regime is illegal. Indeed, in furtherance of that, the court very expressly in its final paragraph says, we encourage the parties, that is the Israelis and the Palestinians, to negotiate the end of the occupation, right? So there's the negotiations condition, which is again affirmed by the principal judicial organ. And that's a problem that, from my perspective, offers an entry point in answer to Lena's point about how to manage the tension that exists between power on the one hand and law on the other. Go back to the court, ask them whether or not Israel's continued presence in what is supposed to be a temporary situation, but now 54 years, whether Israel's continued presence in the occupied Palestinian territory is legal. And if it isn't, what are the consequences of that in international law? I can tell you as an international lawyer, the consequences are that Israel must quit, that is, remove itself unconditionally from the occupied Palestinian territory. Now, will a judicial opinion of the ICJ of that sort produce the end of the occupation? Likely not, I readily admit. But what it will do as well, and this is again going to the point that I'm trying to make with you, Lena, what it will do as well is help reshape what the contours of legitimate political discourse over Israel-Palestine are, what they look like, what you can and cannot say legitimately, legally speaking, and even politically speaking. Israel has no legal right to any portion of the occupied Palestinian territory, period, full stop. It must quit those territories in favor of the one people who do have, to the exclusion of all other peoples, the right to exercise self-determination in that territory, the Palestinian people, right? So we need to find those entry points and use them. And that requires using international law, the same international law and institutions that sometimes can be abused much to the great dismay of the subaltern classes, including the Palestinian people, and in other contexts, others who are weak.
Thank you so much, Imseis. Randa, I would love to hear from you as well. If you have thoughts on this, please
Well,
go.
I see the point Ardi mentions about another advisory opinion, and maybe that would be helpful. But again, it would not end the occupation, definitely, because we've seen also advisory opinion. I mean, I think I cannot argue more in depth from a legal point of view, because yes, it was in a way or another limited on the wall, but the advisory opinion on the wall. But you know, I was looking at the issue of how much that would be helpful to address the issue of Israel's continued presence and the legal implications on that. Probably it will add up. I'll back up on this one, maybe. Very, very modestly, and say I cannot argue more on that. But what is really, even whatever resolutions we have or advisory opinions, whatever, require, as a practitioner and being a human rights defender, more than only looking at law from an academic approach and so on. I think that with the advisory opinion on Namibia, and the apartheid regime in South Africa and Namibia, it took around 30 years to see the actual end of the apartheid regime there. So to us, I think we have to look at other alternatives, and these alternatives should build up on the already changing momentum that we have witnessed lately and build on it. We've been seeing the BDS movement growing. All of them are peaceful means of rejecting occupation and showing the Israeli illegal practices and so on. The boycott divestment movement should be encouraged. The popular movements, solidarity movements around the world should be further encouraged. You know, during this year's military incursion on Gaza, we've seen the whole world moving against it and in solidarity with the Palestinian people, especially in the United States and in Europe and in many countries that we think really this is really becoming a real change. Even Palestinians inside Israel were joining efforts with the Palestinians in the occupied Palestinian territory. We also have seen developments. I think the main problem is that this occupation is continuing with its policies and with facts on the ground with a continued culture of impunity. And the developments that have been taking place with the International Criminal Court as well, and with the starting of the investigations, is a new development that we should really build on, because this is making those who are committing crimes against the Palestinian, war crimes against the Palestinian people, made accountable. Of course, we might not see it coming in very soon, But I believe, honestly, that through initiative of this sort, that we can move forward with more solidarity with other movements supporting the Palestinian cause, our rights as Palestinian people, we can reach to a just and durable solution to this conflict. So I'm more taking the practitioner or the pragmatic part of joining efforts to end a prolonged military occupation, other than maybe another legal opinion or legal advice or other resolutions. But it doesn't really mean that we might not need them. It might establish further our legitimate right to self-determination as Palestinian people.
Absolutely. Thanks so much, Randa. And I just wanted to say I catered the part of the question, at least, to law students specifically, because I know there's some of them here today. But you're absolutely right. These laws aren't just abstract things, and we aren't just discussing them. They govern real life and real people. And so it's very important to kind of have everything in harmony so that we're working a little bit better. So Emily, I'll hand things off to you for the next question.
Yeah, so we have a question from the audience from Ahmed Faza. So thank you for your question that I think builds on this really nicely on the both legal and practical sides, and thinking about perhaps my words now, but a movement lawyering framework. So how do you approach the complicity of the international community, including third-party countries overseeing negotiations of the peace process, but not exclusively? So some examples given are, the US in terms of military funds, weapons industry enablers like the UK and Canada, etc. So perhaps Ardi, you'll have a more legal perspective, but legal and practical question.
Yeah, sure. Happy to answer that. It's a good question. There's no shortage of relevant international and domestic laws that can be relied upon to ensure that third states abide by their own legal obligations to ensure that Israel stop doing what it does. I could use Canada as an example. Canada is obviously the place that is most relevant because we're here. Under Common Article 1 of the 4 Geneva Conventions, all high contracting parties, of which Canada is one, all other countries in the world pretty much are as well, they have an obligation to ensure respect, not only to respect the terms of the convention, but to ensure respect for the terms of the convention. Now, that convention prohibits Israeli settlements from being constructed in the occupied Palestinian territory. So what does this mean in practical terms? Well, incidentally, before I get to the practical bit, this international legal obligation of Canada and all other high contracting parties, but in Canada's case in particular, is domesticated in Canadian domestic law, the War Crimes and Crimes Against Humanities Act and the Geneva Conventions Act as well. These are domestic pieces of legislation here in Canada, which bind the Canadian government domestically, not only internationally by the 4th Geneva Convention and so on. How might practically this sort of look if you want Canada to take a more robust, legally principled position? Well, just by way of example, I understand there's a case now pending before the Federal Court of Canada, now at the appeal level, concerning labeling of Israeli settlement products. Professor Kattenberg brought it from, he's from Winnipeg, the Kattenberg case, where the Federal Court of Canada said, the LCBO cannot label Israeli wine products, that is, products that are produced in Israeli settlements, that is, wines and other alcoholic beverages, as products of Israel when they're being sold, in the stores in Canada. At the first instance court, the court said, yeah, this is illegal, it shouldn't be happening, so stop it. And the Canadian government is spending taxpayer dollars appealing that case. Why ever would they do that? Well, because according to the Canadian government, they have trade relations with Israel that allow them, according to the Canada-Israel Free Trade Agreement, the right to sell, indeed require them, the right to sell Israeli products, including products that are produced in occupied Palestinian territory, and to give them preferential treatment and access to Canadian markets, tariff-free. And so there's another entry point. So not only do you have this case, and you could ask your MP why the Canadian government and the Attorney General is spending your hard-earned dollars appealing a case that otherwise will violate Canada's international legal obligations. But you might also look into why Canada has this element of the free trade agreement. Free trade with Israel is fine. This isn't free trade with Israel. It's free trade with Israeli businesses doing wine production in another country, in occupied Palestine, which is a violation, of course, of Canada's obligation to ensure respect for the terms of the Fourth Geneva Convention, right? So here are two practical things that people in Canada can do, can inquire about, can speak to their MPs about, that go to making, if you like, giving teeth, an edge to the legal obligations that Canada has. Other third states have other similar obligations, and there's much that can be said and written about it. But I think I'll stop there for now.
Well, actually, I fully agree with what you said, and definitely these are some ways where we can really, when you started with common Article 1 of the 4 Geneva Conventions, I really like, when I started my career as early as 87, I was like very much struck with this, wow, this is a legal obligation for a third state party, that if Israel does not abide, then definitely there is legal obligations based on their accession to this convention and the conventions, the four Geneva Conventions. Into international humanitarian law, there are also obligations entailed with accession to international human rights law, and but more stronger because international humanitarian laws speaks about the third state party obligations. Having said all of that, again, what the difference between me being on the ground and working, I know very well that we always reiterated this common Article 1. And we spoke about the grave breaches of international humanitarian law and the 4th Geneva Convention. And I really spoke about the war crimes and so on. I think it's only going to be possible to see a turning point when we really can urge the people of Canada, of the United States, and so on, to urge their governments to take steps. And that's why when we talked when I spoke in the previous response, I really mentioned that what happened lately in May was phenomenal to us. We looked at it we opened our eyes as Palestinians. Yes, the whole world is in solidarity with the Palestinian people. Again, we came at the forefront, our cause has been made. It's only when the people demand that, because I learned it all through my career that people's rights, and through my academic studies at Essex, that only if we put this effort in making the change through working with the people, through trying to influence our parliamentarians, the congressmen and women, and bringing them to our side, and looking where is the common interest. Because what is happening, it all boils down to the economic, political interest of the states with the state of Israel. And therefore, we have to see how we can maneuver around that. How could we embarrass our governments, our states, to really see the interests of the people if they want to be re-elected? And the more we get the people on our side, the more they start to reflect that in the ballots when they go for the elections, and the more the interests of the politicians is being affected. Apart from that, it will continue to be very nice legal instruments that we have, that we can utilize, and we always reiterate, and we find them as a tool to use for our legal arguments. But it's only through, for example, being always engaged with. We are very much engaged with the UN system, with the Human Rights Council. We try to always insist on the list of companies that are working in settlements in order to ban them. We work with the EU also to try to urge them to actually label the settlement products. All of these gradually will help and further encourage the BDS movement, because this is a movement that emerged as an initiative in the West. Every day we hear, only like yesterday, we heard that Nike decided not to sell to Israel any of its products. Maybe only because Nike wants to sell in the Arab world, but it is benefiting us as Palestinians. So if we look at all these companies, maybe 3-4 months ago, there was this very famous American ice cream also pulling out their products from the Israeli markets. Only if we try to bring in these multinational companies to see how their interests can be made more relevant to them. I don't think because these companies have, I mean, they can boycott Israel or they not stop selling their products in Israel because they want to sell in other parts of the world where they have a bigger market. This is where we can really build on these initiatives and try to encourage them further and try to influence, if we can, in different ways.
Wonderful. Thank you so much, Randa. That was our final question for today, so we will wrap things up. Thank you very, very much to both of our panelists. This legal analysis and drawing on real life experiences right from the ground in Jerusalem has been nothing short of insightful. I'm very happy to have been here today. I've learned so much. And I kind of want to just shoot an email to an ICJ judge right now and just like give him a piece of what I've got. But so I'm going to give you guys an opportunity to say any final thoughts if you have any. But for our audience that are still here, our next steps are clear. There's still obviously much work to be done and much to be learned. But BDS has been something that has been advocated for quite some time. And now what I learned today is seeing the tensions in international law, not as pessimistic, but more as normative, as a given template that we just need to learn how to operate with and find the loopholes within. So our speakers, if you have any final thoughts.
Randa, would you
Ardi,
like to
if
go
you
ahead?
want to say something, Ardi, go ahead because you might be leaving.
Sure. I'd just like to thank you all for hosting us. And I would also like to, most importantly, commend you all for beginning what we hope will be a continued place and space for speech, discussion of all things Palestinian. I like many of you, would have been influenced by the great work of Professor Edward Said, who always reminded us that instead of being represented for, we should be having our agency acknowledged and be able to make representations for ourselves. And so this opportunity is a great opportunity and one that we must celebrate. And I will support you in the effort in any way I can. So thank you very much. Anybody who has questions about public international law as it relates to the question of Palestine or any other matter, frankly, on planet Earth, or even in the celestial areas, please contact me. I'm at Queen's Law School. My email is on the website there. Take care.
Thanks so much, Ardi. Randa, you can go ahead.
Yeah, thank you, Lina. I really want to thank you very much for inviting me for this very interesting opportunity. And I hope one day I can be physically with the students, law students in Canada at Toronto University, and speak to them face to face, because it's not the same being online and speaking here. Maybe also I would have very much liked to discuss how patriarchal structures and colonial occupation very much intertwine and influence each other negatively very often and create additional burdens and oppression on Palestinian women specifically. We have to deal with more than one form of oppression as Palestinians and Palestinian women living under occupation, and at the same time within a patriarchal structure. And I think the two systems feed into each other and enhance each other at the expense of and even further overburden the lives of Palestinian women and girls living under occupation and within this patriarchal structure. I want to encourage you all to contact me directly if you wanted to know more about these issues, and visit our website, because we've put the voices of women, strong Palestinian women who speak in their own voices through the testimonies they give, in order to bring to you livelier the human stories of Palestinian women living under occupation. So please don't hesitate to visit us. We do very nice submissions, evidence-based data that we always put on our website, and therefore please visit our website and contact me personally whenever you needed anything on gender issues or on the Israeli military occupation. If you want from the practical side, come to me. But if you want from the academic legal point of view, pure legal point of view, I'm more an activist, but you have Ardi with you. So really, thank you very much again for giving me this opportunity to be with you today.
Thanks so much, Randa. A wonderful balance.
And can I just say thank you both so much for coming. This was wonderfully educational, and indeed we hope to host you both here in person one day soon, without a pandemic and other issues that we're dealing with at the University of Toronto. And Ardi, when your book comes out, and Randa, as soon as we can. Thank you both for coming. And I encourage you all to come to our events next week. We have a wonderful event. The links are in the chat on mapping, what the name? Mapping Palestine. And also Century U of T has a wonderful event just after ours. So we hope you come. Thanks so much, everyone. Bye-bye.
Thank you very much.
Bye-bye.
Bye-bye. Thank you very much.